Hi guys, it's Kathy. I hope you're doing well. Sorry, I was reading a fanfic and I lost track of time. It happens. I was reading. I was immersed. Oh my god, guys. I don't even know what we're about to watch. It's freaking crazy. Alright, it starts off insane. And we go through a whole insane hearing. And then it gets insane. And then, out of nowhere, out of left field, there's no way you're going to be able to tell how his hearing ends for him today, because it's absolutely insane. It's crazy. You'll see. Buckle up, because this is insane. Here we go. I'll get Twitch and end that up. Don't worry. I have to start.
Yeah, Jesse, whatever you want to say. Yep. When the court's ready, can the clerk call Jesse Knoll?
Yeah, let me just make sure we got everything else done. Okay, Jesse Knoll's cases, 23 CR 1731, 24 CR 1187. Appearances, please.
McKenna Mayfield and Brad Sherman for the people.
And Your Honor, good morning. Eric Zale and Brian Emerson on behalf of Mr. Knoll, who is present.
Okay, so we're here originally for a check-in on that subpoena to Meta. I see that they filed
Subpoena for Facebook.
or their lawyer filed a detailed objection. So is there anything
I think before we address that, I think we should probably address the threshold matter, the motion to withdraw.
okay.
Because Mr. Emerson does have substantive argument as it relates to the subpoena response, which I found it entertaining. But I think Mr. Knoll has some comments that he would like to make in a relationship to the motion that we filed to withdraw.
Okay, so just one moment here. Let me just get everything. Just 1 second, sir. So let's get everything ready here. So,
Just want to discuss that with me before you discuss it with the judge. You're still my lawyers. This is what I'm talking about, dude. Like, you discuss this with me.
defense counsel filed a motion to withdraw on May 11th,
What you just said.
set for trial May 18th.
What you just told the judge.
All right, Mr. Knoll, I'm talking now. Mr. Knoll. Mr. Knoll, I'm talking, so stop talking. You have been somewhat disruptive, and you've been pretty hard on your lawyers, and I've seen that myself. I'm going to warn you that if you're disruptive today, I will find you in direct contempt, and I will sentence you to jail immediately. So you have to be calm, cool, respectful. But I do want to hear what you have to say, and if I have to cut you off, I'll do that. People, why don't I just excuse you for a moment? We'll call you back. So we'll seal this portion of the record and we'll just talk for a few minutes. And then I'll call the people back in. So, Mr. Null, you wanted to, what do you want?
What I would like to do is,
Okay. You're about to get vomited all over with crazy. Okay? And he is long-winded with his crazy. But once he's done with his crazy, then it gets even more crazy. It has nothing to do with him. But then it even gets more crazy when he is the center of attention again. So just he's long-winded, but we'll get through it.
just let you read this because I'm not an open speaker and, when you read this, you have to understand my frustration. I understand I would just rather read it, it's just be a lot easier for it to read, because I feel I would get a little, emotional about it. So can I get this to you to read?
I think you have to read it. I have to hear this from you.
Your Honor, I respectfully but urgently request new alternate defense counsel a continuance in the order compelling for discovery under Colorado Rural Criminal Procedure Rule 16. I have fired 3 previous ADC lawyers due to complete breakdowns in communication and the refusal to listen or investigate. Current counsel Eric Zale and Brian Emerson had been on this case for since August 29, 2023. That might be wrong, might be 2024. Nearly 2 years. In that entire time, they have met with me only about 3 times outside of this court. Outside of court, like not right before court. Now, this representation has been grossly ineffective after almost 2 years. The entirety of their defense strategy is simply to argue it could have been anybody. This is completely inadequate for such a serious felony case. I have repeatedly provided counsel with clear evidence that my Facebook account was accessed and without authorization. My own Facebook activity report shows I never sent, received, or accepted any friend requests from the undercover profiles, yet these profiles appeared on my friend list and received a forwarded messages. The same thing happened to at least other 28 people that I know accounts. The report also shows impossible activity login, such as me logging into 14 different devices in 1 minute. I sent them to. Counsel has refused to proceed this obvious and critical defense. They filed a watered-down subpoena to Facebook that was not honored. They have done almost nothing to investigate whether my account was hacked or compromised. That my account was unlawfully accessed. The evidence obtained is subject to suppression under the Proof of Proportion to Street Doctrine. This refusal to investigate this defense after nearly 2 years is unacceptable. Additionally, additional failures include lying to me on the morning of April 14th, which I had text messages to prove this on my phone, telling me, Jesse, you do not have court this morning. When the day before that, I said I want to make the most of that hearing, so obviously I wanted to be there. He said when I went anyway, counsel claimed he lied to look out for me because of my dog, even though he had previously, this is important here, even though he had previously asked me to meet him at a playground in a children's fishing pond. Locations are highly inappropriate given the nature of this charge.
They don't actually say the charges, but what they do say is that he was messaging undercover officers. So, and then he just said that his lawyers asked him to meet him at a playground, and that's inappropriate due to the nature of the charges. Okay, so that's all I'm going to say about his charges. Okay, I'm going to tell you something though, guys. It's getting completely out of hand. I looked at 50 dockets today. 17 of them had absolutely inappropriate charges in them. And the next batch, I looked at 150 next dockets. 8 of them had, just children involved. It's getting outstandingly bad every day. Just to dig through to get court cases, you gotta listen to all this horrible garbage. But there was no victim in this crime. I do know that. All he did was message an undercover officer.
Taking 18 months to obtain 4 different phone extracts from the law enforcement while never informing me of the delays. I was left believing that we were waiting on Facebook records. I didn't know it was, I just said, okay. Refusal to speak, let me speak meaningfully with their technical expert, never discussing my separate credit card case with me, other than one comment that it was BS. Refusing to file for a discovery. I specifically requested, despite text messages, proven I told them that I have a constitutional right to all evidence used to obtain the warrant for my phone. I have not seen any motions counsel has filed. They have shown me nothing. This is not effective assistance to counsel under Strickland versus Washington. It is ineffective and has left me without meaningful representation in a very serious case. I request new alternate defense counsel. I request a continuance of sufficient length so new counsel or if I force to proceed pro se, can properly investigate unauthorized account access defense and prepare for this case in order allowing an independent digital forensic expert to examine my phone and all raw extraction data from the law enforcement in order compelling full discovery, including the search warrant affidavit, all materials from the officer's device, raw material extractions to complete Facebook meta records, neoprint, full message history, login, friend requests, etc. The Facebook stuff obviously is one thing, but because this is off the record.
Officer, can you test him real quick? Can you take him away to get him tested real quick? I'm just curious.
Well, it's on the record, it's just without the people. So don't say anything that's going to
Okay.
harm your case.
I misunderstood that. These defenses, should have been addressed. They can be addressed. I have a right to look at all evidence under, Colorado Rules of Procedures 16 and just, some other thing that I have on here. And the officer's phone and stuff like that, in order to sit there and prove what they were saying, to get that warrant. And in order for me to attack that, 'cause I have a right to face all my accusers, and that, they said on their phone, this is what was happening. Even though there's no proof it was even me texting that thing. And then even though that might be the defense, I would rather prove that it wasn't me. There was a big difference there. I don't want to sit there and put the rest of my life on the line, discharge and everything like that, based upon my lawyer just saying, you know what, it could have been anybody. You can't prove it was him. I mean, that's a very sloppy defense after a year and a half, when I just pointed all these things out, all these different ways that they can sit there and attack this. And they have done nothing. And then when they filed the subpoena stuff for Facebook like three or 4 months ago, it was only because when I came here that time, they thought I was here to fire him. I said, no, I want you to explain to the judge, well, all this nothing that you have done for my case. And then that's when they said, we'll go ahead and decide we're going to file this stuff for Facebook. You know what I'm saying? And everything I keep hearing out of this man's mouth is, you can't, we won't, you're not going to be able to, nothing. Try something. This is not some bubblegum case. If I'm being rude, I'm going to apologize right now because I'm not trying to be. I'm just going to shut up. I'm pretty sure
Okay.
you got the.
No, thank you, sir. And I appreciate you staying calm. I know this is an important case for you. So basically, you want me to assign you a new alternate defense counsel. New lawyers.
Yeah, I would like to get somebody who is more technically sound as far as like, I don't know if you could do that. Like, you know what I mean? Like technically like knows more about the computer
Okay.
stuff.
Thank you. So let me see if the current lawyers have anything they want to say that's not privileged. So Mr. Emerson, Mr. Zale.
Your Honor, unless you have any specific questions for us about what Mr. Knoll said, I don't think we have anything to add at this point.
Because this is important, I'm just going to talk for a few minutes and make some findings. I have told Mr. Knoll on several occasions, as has Judge Salamone, that this is the last ADC counsel he will receive. Under Ronquillo versus People, the right to counsel does not extend to a defendant who requires counsel to appoint him. He is guaranteed only effective assistance of counsel. An indigent defendant who wants to replace his court-appointed counsel with another court-appointed counsel must show good cause, such as conflict of interest, complete breakdown in communications, or other irreconcilable conflict. The defendant has not shown that. He is just frustrated with Facebook and frustrated with the charges against him. I am going to deny the request, as I have stated and warned the defendant on numerous occasions that this is his last ADC counsel. He's not getting new ADC counsel as he requested. These lawyers are very diligent and competent, and from what I've seen, have advocated zealously for the defendant. In addition, under People versus Brown, if I were to substitute counsel, I do have to take into account the events surrounding defendant's request. Defendant has burned through numerous ADC counsel. He has had conflict with 3. That tells me that the issue is with him, not with the lawyers. Sometimes there's a personality conflict with one lawyer, but not 3. If I were to hire a new lawyer for the defendant, we would have to continue the trial, and we may have to discuss that, but I am not going to do that. The conflicts that the defendant has are not related to the representation that these lawyers have given him. They're related to his frustrations with the evidence and with the charges against him. I will therefore deny the request of the defendant to appoint yet another alternate defense counsel. So I'll bring the people in.
Okay, we made it through the first batch of crazy. We made it out alive. Now, while the second batch of crazy goes on, the third crazy comes out of nowhere. And Bobby, you should pay attention to what happens here. Because this is what I fear for you someday. You'll see.
Mr. Emerson will grab the prosecutor.
So they're still my lawyer?
They're still your lawyers?
Hey, CJ, don't. Do not put it on double speed. Whatever, she'll be fine. I should have put this whole thing on double speed.
All the other issue about like, so they're gonna have to file these motions?
Now I'm going to talk to the lawyers once the people are here.
Okay, sorry, I just didn't.
Okay, so why don't you just step back, Mr. Null? Prosecutor will unseal this portion of the record. I heard from the defendants. I made findings under Ron Kelo and Brown and denied the defendant's request to have new ADC counsel appointed for him. Now we have the issue with the subpoena to Meta and the trial setting, which is for Tuesday, the 19th, next Tuesday.
Okay, now this is our next batch of crazy. They subpoenaed Facebook to get records from Facebook. And believe it or not, Facebook's just not listening. Because it's very difficult. You can't just subpoena Facebook. It just doesn't work like that. So the next part is crazy because they're subpoenaing Facebook, and this lawyer does talk a little bit, and it gets so bad that something happens. So here we go.
So, Mr. Emerson, I did see the objection by Meta's lawyers. What would you like to do here?
Judge, one correction about that. We filed that. It was sent to me via email yesterday, and I filed that so that everyone would know what we would be discussing today. That is an important issue. Let me just remind the court where we are factually. We filed a subpoena, Ducis Tecum, a while ago, several weeks ago. It was set for return last week, which Meta did not respond to via filing a motion or a motion to quash or an objection, nor did they appear in court. And we set this over today. The court had us submit a subpoena to Your Honor for Your Honor to sign. We then served that on them, and we got that letter yesterday objecting. What we're asking for in terms of relief today, and I'll give some reasons for this, but I want to lay this out first, is we're asking the court to issue an order compelling the production of the documents, and also to ask Meta to show cause as to why they have not responded to the original subpoena properly, did not show up in court to address it both last week and this week. It may be too early to reach this conclusion definitively, but it certainly feels and smells like Meta thinks that they don't have to respond to this court, that they can do whatever they want, and
It's because they don't have to respond to your court and they can do whatever they want. This is your first day in America?
essentially is telling this court to go jump in a lake. And the arguments outlined in Meta's response are simply mostly false. And they should not decide how this court rules. What they've essentially done over and over again is they've invoked a civil procedure to avoid a criminal procedure. And you'll notice that they rely heavily on Rule 45, Your Honor. But a criminal rule, that's a civil rule. Criminal
I live my life by Rule 45.
Rule 17 is what governs here. And under Criminal Rule 17C, the exclusive avenue for challenging a motion to quash or challenging is filing a motion to quash with this court and then potentially showing up. So they filed nothing, as I indicated. Their letter is not a motion. Their letter cannot quash a criminal subpoena. And the objections they raised have not been properly presented to this court, either last week or this week. And the subpoena should be enforced. Now, it's notable that it's our position that they've already violated a court order by not responding to the subpoena, which was signed by this court. It wasn't just issued by myself, it was signed by this court. Now, based on procedural grounds, this court could grant us the relief we're asking for and just ignore the letter that's been filed. But I think we should address the substance nevertheless. And so I want to briefly do that. I think one of the main arguments made that I find alarming and why this smells so bad is that Meta is trying to argue that this court has no subpoena power. And again, we talked about this last week, but they seem to suggest that they can't be touched in Colorado. They really can't be touched anywhere unless it's Delaware, unless it's 100 miles from Menlo Park, or unless we go through a lot of out-of-state procedures. And they rely on a case called Colorado Mills LLC v. Sun Opta, which is in their letter. And they rely on that improperly. So what that case essentially finds is that if the company, the corporation has no business, they have no offices, they don't do anything in the state, they don't have a registry agent, well, in that scenario, then maybe there's other procedures that have to be taken. But when a company does, like Facebook, have business, Meta, have a business in Colorado, they have an office in Denver, they have a registered agent who we've served twice with a subpoena. When those two factors exist, when they actually conduct business within a state, they are subject to that state's courts, to that jurisdiction of those courts. The Colorado Mills case involved a company that was not incorporated in Colorado, was not registered as a foreign agent in Colorado, it maintained no office in Colorado, and they were served outside of Colorado. So none of those facts apply here. Those are all opposite in this case. And if we look at Mallory v. Norfolk Southern Railway, which is 600 U.S. 122, when a company registers to do business and appoints an agent for service, they're basically consenting to that form's process. So personal jurisdiction and subpoena power and personal jurisdiction are different, but they're related. So when personal jurisdiction is then conceded by registration, the subpoena power in most instances should follow. And so that argument just fails that there's no jurisdiction. I think this court knows that it is jurisdiction, and the court should certainly enforce that against Meta. The other argument they make, Your Honor, is that the SCA, well, they talk about the Uniform Act, but that simply doesn't apply here because of the reasons I just stated. And they're referring to 16-9-201 at SEC. And then they rely on the SCA to say that the SCA bars a subpoena, but we conceded last week and we tried to take.
Sir, but how can you enforce anything that you're saying? How can you enforce it? So, okay, all right. Let's say Meta does not produce the records, which they're not going to. He's right. They have to, right? Except they won't. So what's going to happen? The judge is going to have a show cause hearing they're not going to show up to. Or they do show up to. Doesn't really matter. Then he's going to fine them. He's going to sanction them. $2,500, $5,000, whatever. They don't care. They don't care if it's millions of dollars. That's nothing to them. It's a drop in the bucket. They'll gladly pay it. Leave us alone. Here's your sanction money. We're still not getting the records. There's no way to enforce it.
Tailor our subpoena to only target things that were not content. Now, they make some allegation in here about public posts being content. I think that's a controversial subject, whether we did ask for public posts. Public posts, that's still being litigated, whether that's actually content or not. I would argue it's not since it's public. And the larger issue with the SCA is privacy. But nevertheless, we're not looking for those things. We're looking for IP address information, logins, things of that nature. It's very clearly spelled out in our subpoena, and so the argument about the SA frankly misses the mark. They don't really talk about Spikestra and whether we've made our showing there, but we'll discuss that briefly. There's requirements under Spikestra for a subpoena ducis tecum to be valid. Reasonable likelihood that the materials exist. Well, we know these materials exist. They keep all this back-end information, so it exists. It is evidentiary and relevant because, as you heard from Mr. Nall, one of the things that he would like to argue and that we're trying to accommodate in terms of our defense is that there could have.
He was texting the undercover cop, thinking it was a child, through Facebook Messenger.
been other people involved in this case. And certainly we have evidence from the extraction we received that there were numerous people, more than 10 other email addresses other than Mr. Knowles who signed into his phone, signed into some of his apps. That is not uncommon in the community that camps here in Boulder. And so getting that information would be evidentiary, and it would be relevant to this case because the people certainly have to prove that Mr. Knoll is the one who was doing the communications with the undercover officer.
They can't just get it from his phone because allegedly there were 14 other devices that logged into that account at the exact same time. So they need the information from Meta to prove that. There's no way to prove that without going to Meta to prove that.
It's certainly not procurable by other diligent means. There's no way we get that back-end information or all that other information we've requested other than through a subpoena ducis tecum to Meta. We believe it's needed based on the defense that I just outlined. We do believe it's needed for trial preparation. And because of that, we know these exist. We know that they would have evidentiary value. It's certainly not a good fishing expedition. This is done in good faith to present the best possible defense, the most effective constitutional defense for Mr. Knoll. The last thing I'll emphasize this. There are some significant procedural defects in what Meta has done here. They are either confusing Rule 45 and Rule 17 because they don't do criminal work very often, or they know that Rule 17 applies here, but they like Rule 45 better. But because Rule 45 does allow someone to object to a subpoena ducis tecum by simply objecting to the party who issued the subpoena. But that's not the case here. So they've now failed to respond properly twice. They failed to show up twice in court. I did email the attorney, I can't remember his name off the top of my head, to see if he was going to show up today, and he said he was not going to show up today. So that confirmed what their intent was, and it feels like their intent is to basically thumb their nose at this court and not respect the jurisdiction of this court. So we were asking for the court to issue an order to compel the discovery that we've requested, or the documents we requested via the subpoena ducis tecum. And we'd like the court to ask them to show cause to do that within 7 to 14 days, whatever the court thinks is appropriate, but something quick. Require them to appear by a counsel of record or a custodian of some sort. I think counsel now would be appropriate given counsel's entry into the case, at least via letter. And then have them either A, comply with the subpoena or properly move to quash in a procedurally appropriate way under Colorado rules and under Rule 17. And then obviously the court can issue contempt. I think we can reserve that, can hold them in contempt. I think that can be reserved at this point to give them the opportunity to respond via counsel. And that's our request, Your Honor.
Okay. And then any minute now, probably sometime within the next 5 minutes, I don't know exactly when, try to watch the defendant even though we can't see the defendant. Okay?
All right, so under Rule 17C, the court on motion made promptly may quash or modify the subpoena if compliance would be unreasonable or oppressive. So what defense's position is that they have not made a proper motion to quash or modify.
Speaking of proper motion,
The letter just doesn't cut it. Is that about it?
It's not, the letter doesn't cut it substantively, but procedurally,
procedurally.
it's inappropriate, yes.
Right, and then substantively, there's other issues. Mr. Zale?
And I apologize, if we could pause this for a second. Mr. Knoll just informed me that something is happening with him physically. And so I informed the sheriffs and they just called for an EMT.
Okay, thanks.
So I just wanted to let everyone know.
Thanks, Mr. Zale. Thanks, deputies.
all right, Bobby, the part I need you to listen to is at some point in the next couple minutes, probably that female lawyer right there, our female voice, asks him a question. And his answer is what immediately made me think of you.
Okay, let me just see to button this down once Mr. Null is.
Some water help you?
Where'd you put it?
0, no pain, 10 was pain at 7 or 8. Security 642, if you can have them respond to emergency, please. We've got people here, right? Well, we've got medical on the way. So we don't have anybody stationed here.
Is there someone I can take care of?
Where's Steve?
There's someone watching on my phone.
That's fine.
Outside like over in that house?
Does it, I know you're in pain. Are you more comfortable sitting? Are you more comfortable standing, laying down? What do you?
This is not cold.
Have you experienced this before? Sir, have you experienced this before? No, first time? Okay.
Okay.
Push the red button, Judge. Right there it is.
Okay. Yep, we're gonna,
No, she's got, please don't do it, but she don't know the shit, no.
we'll figure it out. Yes, we're not gonna.
Your attorney's going on. Eric's going to take a look at that.
I want
Would you like to go blurring? Yeah, it's off for JDB Lucy.
Have you had anything to eat this morning?
The way you're holding looks like the coffee.
Did you hear that, Bobby? It was hard to hear, but did you hear it? I think she just asked him. I think that was the part. It's hard to hear. I think she just asked him if he had anything to eat today. And he said a donut and some pepperoni. That's what he had to eat today, a donut and some pepperoni. And now look, he's on the ground in the middle of a courtroom. Start eating lettuce instead of peppers. Bobby, we don't want you to be on the ground in the middle of a courtroom. We want you to be in the courtroom. That's a fact. I want to see them handcuff you and take you off with you screaming, justice, justice. But we don't want that. We don't want you on the floor because you ate pepperoni and peppers and bugs.
So donuts, some pepperoni.
Did you say pepperoni?
Pepperoni, cheese, and
Yeah, pepperoni will do.
So is your pain down below your lower abdomen, or is it more up here in your esophagus?
Well, he's holding.
Right there. Okay, stop. All right.
it.
Well, like I said, we've got medical on the way. Is it okay if we don't want to interrupt proceedings, but is it okay if we walk him out to where medical's gonna be? Or
I think you guys should do
does
that.
medical need to come?
I think that's more important.
Okay. All right. We got you, man. Nice and slow. We're just gonna get you.
Cost only, it's from the fence. Not good.
So he's not complaining of chest pain. He's complaining that his belly hurts. So he's not having a heart attack. Well, I don't know. I'm not a doctor.
Security.
I told you, keep motions in mind. He needs to file some motions, Judge.
All right, Mr. Emerson, just to make a short record, defendant had some distress. The deputies gave an initial examination. They called EMT. Defendant was gently removed from the courtroom voluntarily with the deputy's assistance to meet the EMT personnel. I think he was complaining of some abdominal pain and appeared to be in pretty severe
Tummy ache.
distress. Is that about what happened?
That's what happened. He described it. The deputies asked him to put it on the pain scale of 0 to 10. He said around an 8. He seemed to be in quite a bit of distress. I agree with the.
Okay, so
report.
Mr. Emerson, we don't have the defendant present in this criminal proceeding. We're right in the middle of discussing this Rule 17 subpoena issue. Are you able to proceed without the defendant present, just so we can button this down?
I am comfortable waiving his appearance for this limited purpose.
Okay. Okay, so I'll accept the waiver for this limited purpose. It's largely procedural, and the defendant had stated during the Burger Rut hearing that he wanted these documents from Facebook, Meta, and his lawyers were advocating for that result. Okay, so people, thanks for your patience. Do you have any position on what Mr. Emerson just stated regarding the non-compliance with the subpoena I issued to Meta?
He's like, I don't care what you do with Meta. It has nothing to do with me, sir.
Your Honor, I don't think we take any position on it as it relates, I guess, to the argument or what Mr. Emerson is asking the court to do. We don't have a position.
Okay, so Mr. Emerson, from what you said, I take it you would be requesting a continuance of the trial that's set for the 19th?
Yeah, so we would have no choice but to do that under the circumstances. We believe there would be good cause for this court to exercise its discretion to grant that. It's part of what Mr. Knoll has been requesting as well. So he would be willing to waive speedy in order to accomplish that.
Yeah, and Mr. Null did state that he wants these documents, and I find that counsel's representation is consistent with his requests both at the last hearing and today. Statutory speedy trial is currently set to run till August 13th, 2026, having been reset on February 13th, 2026. So people, first of all, any objection on continuing the trial based upon defense request?
Under the circumstances, no.
Okay, thank you. Appreciate that. And then we can talk about resetting the trial and timing and a consistent waiver of speedy trial under Colorado statute if necessary. So, Mr. Emerson, I could set a show cause hearing, issue an order. I think we already have the subpoena, which is an order.
Mhm.
I could issue a show cause as to why they shouldn't be found in contempt for violating my subpoena order. We can do that as soon as tomorrow, Monday. If we're continuing the trial, I'm probably pretty free next week. I don't know what timing you were thinking.
I think next week would be a wise use of that time. It gives everyone a chance to be ready for that, although I'm largely ready to do it. I guess and I'm fine with that procedure. I guess the question is whether the court also wants to issue an order to compel. I know that I agree with the court that Your Honor has already issued an order and that should have been respected as an order. The court could do that as well, but if the court just wants to have that hearing to show cause, then let's do that.
Or maybe you can count to 3 for Facebook and see if they reply. 1, 2, maybe that'll work.
Okay, people.
I think, sorry, Mr. Mayor. I think my concern is, and I don't think this is what happened, is that we file a subpoena. It was clearly signed by the court. I guess there is the potential that it could be interpreted as just a subpoena. It shouldn't have been interpreted as a subpoena issued by attorneys, but it didn't look like a formal order, and maybe that falls on us. We could have had you do that, and that's falls on defense's shoulders. But if the court did issue an order that looked like an order, there would be no mistaking whether it was an order or not, whether we then have to give them a chance to come to another return before doing a show cause hearing, that I'm not sure. But but that would be one alternative procedure, which is just the show cause hearing at this point.
Okay, thank you. Ms. Mayfield.
So I'm sorry, Judge, what exactly is the court's question for the people?
Well, the question is, I could just issue a show cause as to why they haven't complied with the subpoena. Or what Mr. Emerson is suggesting is that I actually issue another order. I've already issued the subpoena and we signed the subpoena, which is not what we do all the time. And simply have the show cause, basically it's do a show cause hearing or an order, give Facebook time to comply. If they don't comply, issue a show cause, or if they formally object under Rule 17, we would probably have a hearing on their motion to quash.
So
Judge, they're objecting under Order 45, not Rule 17, but that's all right. Continue.
a couple things. I don't know if we can really have an opinion. I don't know that it really impacts us either way. And frankly, I've never been in this position before. So I don't know what the best course of action is off the top of my head. I certainly trust the court and Mr. Emerson to decide what's best for the court's schedule and what they're trying to accomplish. I think our main concern is just getting to trial at some point, hopefully this year.
Right.
Which is understandable. I think what we're talking about, Judge, is really how much you want to hold them to the fire here, right? If we do the show cause hearing right away, that's saying to Perkins Coie and to Meta, hey, what are you doing? You need to come and address this, and you need to do it now. If we give them another chance, you're giving them a little more leeway. So I think there's two different options in terms of how strict the court wants to be here.
Yeah, I hear you. I think that they've defied a subpoena without proper compliance with Rule 17C. They have a right to object. They have not properly objected. A firm as expansive as Perkins Coie from their Seattle office should have Colorado criminal lawyers who could
They're going to have the undercover agent testify, but there's no recording. It was through Facebook messages. So the undercover agent went online pretending to be a child, like a 14-year-old girl. And this man, this is just what I think. This is not what I know. I didn't hear any of the evidence. This man started to chat with this person thinking it was a 14-year-old girl. And then this man, said some suggestive comments and then wanted to meet up with her and then got caught because it was an undercover officer the whole time. Okay? So they have his phone. And they have the Facebook messages to the officer, and they have the officer's phone or whatever device he used. So they have all the text threads of these two communicating. But the defense is saying it wasn't him. Someone hacked his account. And we know that there were 14 devices that logged into his account within 2 minutes of each other. So we know we can prove that someone definitely hacked his account. All we need is Facebook to give us that metadata that shows 14 devices logged into his account at the exact same time. Or 14 different email addresses, or 14 different ways his account was logged into by different things 14 times in like this real short span of time. I don't know exactly how they know that information, but that's what they're trying to get from Facebook. So yes, they're definitely going to call the officer in, and the officer's going to testify that he was engaged in conversations with this guy through Facebook Messenger chat, and this guy said these words to him, blah blah blah. They have all that, but the defense is saying, yeah, okay, that happened, but it wasn't him. It was somebody else. So I don't know what's going to happen because Facebook is never going to just say, oh, okay, here's all your data.
explain the situation. So what I will be doing is issuing a show cause as to why they shouldn't be held in contempt, and we'll set a show cause hearing. I know your schedule just opened up. We could set it for a week from now, and I'll issue the order today. And defense counsel can give a courtesy copy to the Perkins Coie lawyer
Yes, I will.
and CC the prosecutor. We could set Thursday, the 21st at 9 o'clock, if that works for folks.
I'm here on another case at 8:15, so I can accept that date. I don't know about Mr. Zale. Let me see.
He might be coming now.
Make sure your client eats oatmeal that
No,
morning.
just so my notes are accurate, did we set a new speedy trial date?
No, right now we still have that August 13th
Okay.
statutory speedy. I think with defense request, we could have a 6-month resetting as of today, but we probably don't need to do that. And Mr. Nall is not here, so we should probably
We could probably just deal with that next week.
address that when he's present.
Yeah, and that would give time. I was going to ask to set off the record anyway, because I think scheduling is complicated and, they have an out-of-state expert and we have an expert who's mostly in state, but we would need to just make sure they're available.
Okay, and is this CSAM or procuring or there's no victim?
Correct.
Correct. Okay, that's
We have not been.
there's no VRA issue. Okay. Okay, so people, does that work? Thursday, 21st, 9 o'clock, show cause hearing.
That'll be fine.
And if there's an issue with that, Mr. Emerson, for Mr. Zale, just let us know.
I will. I'm sure if there is, I can certainly handle it. So we'll be here one way or the other.
Okay, I'll issue an order right as soon as we're done here, and defense counsel will give courtesy copy to Meta's lawyer, Delaney Butler at Perkins Coie in Seattle. CC the people with any correspondence. And if defense counsel wants to try to have a meaningful conferral with Meta prior to the hearing, I encourage that. But obviously that's a two-way street.
There was an offer of that yesterday afternoon, and so I didn't take it as seriously given the timing of it, but we will explore it.
Okay, thank you. So we'll vacate the trial, we'll reset speedy, offline. We'll see you all May 21st, 9 o'clock.
Thank you, Your Honor.
Thank you.
Thank you.
And then keep us posted with Mr. Nall. Hopefully that was just some kind of acute issue that's going to resolve.
All right. Ouch. If anybody watched my video on court disorder today, you know I found a new judge. It's really good. So I showed one of the clips on court disorder today. I don't know if I'm going to show that one today or not.
Robert Bowers v. David Swearer. Swearer. Sorry about that, sir.
Okay, I got a new judge. You're gonna like this judge. Ow. You're gonna really like it. If you saw court disorder today, you got a taste of her. This is a different case with her. So she's really good. Here we go.
And Judith Swearer. All right. If the parties could approach, please. Mr. Bowers, you are the plaintiff. If you could be on this side and the swearer over here, please. All right. Now, this matter, my understanding is the way I read it from the initial complaint was a property damage claim. And then there was an answer and motion to dismiss filed due to statute of limitations. Typically, statute of limitations claims when a particular claim accrues and whether that claim is time barred by the statute of limitations is ordinarily a question to be resolved by the trier of fact after all of the evidence has been presented. So it is not something that would be a cause for dismissal unless from just the reading of the face of the complaint and the answer themselves that I could make a decision and rule such as by summary judgment on the four corners of the documents there. Otherwise, it is left for the finder of fact during a trial to make that decision. So I assume that the facts will come out in regards to that, and so you have not waived that claim in any way by going forward with a trial. But are the parties ready to proceed in regards to a trial in this matter today?
Yes.
Okay. So we have two cases that are going to trial today. I anticipated only one. Both cases are going to be limited in time. So essentially, both cases will have 45 minutes for each side to present their case and evidence. Is that going to be sufficient for you to do that?
Yes.
Okay. And for you as well? All right. Does either side need any additional time to prepare? Are you ready to proceed?
I'm ready.
Okay, all right, sir. So, Mr. Bowers, do you wish to make any opening statement in regards to the case now?
I don't think so. I think I'd just like to start.
Okay, all right. How about for the defense? Would you like to make an opening statement at all?
I would.
All right.
Do I stand or just sit or?
If you could stand at the podium, that would be the easiest. That way we have a full record of the matter.
Okay. When the Bowers moved into their home, he erected a 4-strand round wire fence along the southern border with our property, a straight line of approximately 1/3 of a mile. Shortly after that, we began having his cattle, particularly one bull, and goats entering our property along this line, especially near our barn and water tank where our cows like to hang out. It was never pleasant dealing with Bob, and rather than attempt to work out something mutually agreeable, we erected our own 4-strand barbed wire fence about 6 inches inside our property, parallel to the Bowers round wire fence along this entire 3rd-mile stretch. We, and Bob at times, would have to remove his trespassing cattle through our entrance gate, which require a lot of herding and corralling using ATVs and at times horseback to get them through the gate. We maintain a herd of about four all-female cows and their mixed calves. We usually sell the calves in the fall to keep our herd at around 4 in.
And they have trouble getting 4 through the gate. They need to go horseback sometimes to get all 4 of them through the gate.
Size. On June 10th, 2021, one of our newborn calves crawled under both fences onto the Bowers property. The calf was very distressed and its mom was bawling for it as it needed to be fed, but the calf wouldn't come across the fences. Judy, my wife, called the Bowers and left a message to see if we could cut the fence, retrieve the calf, and put in a reliever gate for instances when our respective cows might trespass across the fence. We received no response, so we cut.
Okay, so is this just testimony or is this your opening
This is
statement?
just an opening statement. I'm just kind of laying out I'm almost done.
Okay, so this
Okay.
is what you said, okay.
Okay, we received no response, so we cut a 12-foot section of our fence and the Bowers and returned the calf. We immediately arranged for the Snares, a local rancher, to come the next day and repair the Bowers fence and install a reliever gate on our fence. They tried to cut around the wire, they wrapped the wire around the T-posts that were closest to the cut to make the gate open as passable. We paid for this job. We never asked the Bowers to participate. Since 2021, Bob has used the reliever gate numerous times to get his trespassing cattle back on his property. To our recollection, our cows have never entered Bowers' property aside from this one instance.
Okay. The plaintiff like to put on evidence?
Yes.
All right.
My neighbors have a reliever gate for my kids.
Do you need
When they
any exhibit
trespass.
stickers? Or any
I
document?
don't know, do I?
Well, if you have.
If
a
I'm gonna
document-
give you stuff?
Yes,
Okay.
yep. And have you provided it to the defense? Copies? Okay, all right.
No, T, that's wrong. I'm sorry. Heifer is that woman who took my parking space earlier. That's a heifer.
Can you hear me all right?
Yes, are you going to be testifying about things?
Yes.
Okay, then I need you up here. I need you under oath.
Oh, do I bring all my stuff up
Yep.
there? Oh, okay.
Where did she go? Why did she leave us?
Robert Bowers.
Hold
the
on.
David
I don't know what
Swearer.
happened.
Of approximately a third of a mile. Shortly after that, we usually sell the calves in the fall to keep our herd at around 4 in statement. I'm just,
I need you under oath.
Oh, do I bring all my stuff up there? Oh, okay.
There we go.
And you won't be testifying from notes. You need to testify from memory about what occurred.
Okay. So would I leave all my stuff here?
You can bring any documentary evidence you plan on introducing with your testimony with you, though. Yes.
Okay.
All right? Like to put those down, I need you to raise your right hand. Yes? Do you swear or affirm under penalty of law that you will provide testimony to the court will be the whole truth and nothing but the truth?
I do.
Thank you. Have a seat. And first, I'd like you to state your full name and spell your last name for the record.
Robert J. Bowers, Bowers.
What would you like me to know?
Well, the reason I'm here is due to the fact, in violation of the statute, they cut my fence.
What statute?
It is 35-46-107.
Okay.
The facts are, there's no dispute that they cut the fence. This calf we're talking about was over in my place for about a week and a half before I left town, and it was eating with my cows. It's a newborn don't walk away from mama.
When did this happen?
It happened, well, I'm going to go along with his date because I don't know. They claim it was June 10th of 2021.
Okay.
When I was out of town, when I came back, I had a voicemail from Dave, not his wife, who said, I cut your fence, but don't worry, I'm going to put a gate in it. There was no reason to respond. So as time went on, there was a multitude of repairs. But once you cut the fence, you have to stretch new wire from the H to a corner and tight, and then put the band separators on it. The fact of the matter is, I didn't worry about it because I was told they were going to put a gate in my fence. This went on forever. And once the fence bags, it doesn't keep your cattle in. So prior to that, the only problem we ever had was if my cows went around the back, where I put them in a pasture where they wanted to climb up on the top, I didn't have a cross fence to block it, nor did they have a cross fence to block them from coming into their land because of the rocks. But in any case, what we're here about is they cut my fence, they promised a gate, there was ongoing affirmations, and it never got done. And this picture I have, number one. Do I need to put a sticker on it?
Yes.
It's noted as number one. This is what it looked like early on. When you look at that,
Okay, so when was this picture taken?
back when it originally happened, June of whatever.
So, and you have a
21,
copy
I
of this
guess.
picture?
I think we do.
All right, do you agree that that is the way the fence looked back in June of 2021?
We do.
All right,
So this contraption is not a gate. It's wires stretched between a couple of logs. Additionally, it's not on my fence line. My fence line, you have to bury posts, brace them, and mount a proper gate to it. This became the bone of contention. As this went on, the wire bags, and then they just walk through it.
Mhm.
This one is
right.
Exhibit
So
one.
any objection to plaintiff's exhibit number one?
No.
Okay. Plaintiff's one will be accepted and admitted.
This one is number two. As time goes on, because it's obviously not working,
You're right, buddy.
then we start adding things that do nothing. It becomes a fiasco.
Fiasco is trying to outrun a cow. You can't. you can't. You can't outrun a cow. Cow tipping is big here in Lancaster, and you can't. Don't do this.
And it just keeps going.
Okay, so who do you mean by we start adding things?
The defendant. Because it doesn't work. This fence is loose. I don't know what this is, this temporary gate or whatever. The bottom line is, I was told, I was promised that there would be a gate put in my fence. And again, it was affirmations to that effect as we go down the road.
Right. And this, that picture is from what time period?
It's sometime after June of 2021.
All right. Do you agree that that is a fair and accurate representation? Okay, any objection?
Picture.
Okay, and yes, just the picture. And do you have any objection to the admission of exhibit number 2?
No.
Right? Exhibit number 2 will be admitted.
Exhibit 3 is sometime later. And if you ask me the date, alls I know is it's later than when it happened. This is going on for a number of years as it extends. Now the plaintiff adds more stuff. We just start getting a buildup of things. It's obvious that this is unacceptable. You can see my wire is bagged all the way. We have level straighteners to keep the spacing right. But this is when, once that fence was cut, this is when it became a chronic problem. It got to the end I'm going to say last year, where I would get a call from the, how do you call him? The brand inspector. And he'd say, somebody spotted your bull, go get him. And I was like, no, I'm not going to get him. I can't keep him in. This fence is destroyed and I'm not going to go get him and keep going through the same routine. This has to be repaired.
Right. Is this a fair and accurate depiction of the fence at some point in time?
Yes.
Okay. So any objection to the admission of People's Exhibit or Plaintiff's Exhibit number 3?
No.
Okay. Number 3 will be admitted. All right. Can you hand me Exhibit number 2, please, as well?
Oh. Sorry.
That's right. Thank you.
As this continued, finally last year, I just hired some fence guys to pull down all the damaged fence and reinstall a new fence line from an existing H to the front corner of the fence. This is I don't know if it has to be evidence, but I only have one copy of this.
Mm-hmm.
This is an overall of my property. This circle with the X is where my cows eat. Over here is where the fence was cut. On top of the mountain, you can't see it under the trees. There is no way on God's green earth that calf is going to wander back there. You have to bring the heifer over or whatever. But the whole concept is nonsensical. The calf was not days old. It was a yearling. It was almost as big as my cows, which are miniature Herefords. I don't know that any of that is relevant. The bottom line is.
It really isn't,
It
whether or
isn't.
not your
None of
fence
it's
was
relevant.
damaged. So here's the question. First of all, have you seen this other?
No.
Okay. So you haven't shown them that?
Do I give them this?
Yes, they need to see that. Here, just,
This is the that's where they eat, and that's where the cut is. Oops, sorry.
Yeah, I don't know where they eat, but
Yeah,
you have the cut marked is right.
okay. So you'd agree that that is where the cut mark in the fence is located? All right, thank you. All right.
so I guess what I would like to say is none of this stuff is relevant, other than the fact the statute was violated, it was cut, I had a promise, I was misled, the gate was never installed, and it's just ongoing and ongoing. And apparently from discovery, I see that there's some question about statute of limitations. And I would only say, I believe because of the promise and the affirmations, as
This case is silly, but it ends great. And the next case is even better.
time passed, that would either toll statute of limitations, or I would suggest that promissory estoppel could be applied. Because I did count on the promises that they had made when they destroyed my fence. Mending a fence is not a repair.
Right. Any other testimony you'd like to present?
I guess not. I mean, that's the whole thing.
Okay, all right. Did you want to admit that map as demonstrative evidence, or was there an objection to the admission of that map?
You know what? I guess I could put a sticker on it.
Okay.
What are we at, number 4?
Yes.
Hey, that's how many cow they have.
Oh, one other thing.
Mm-hmm.
Actually, 2 other things.
Okay,
The fence repair cost me $4,500.
okay. Do you have any receipts or anything?
Yeah, I have all that. Do you want me to get them now?
Uh-huh.
I prefer to burn fences, not mend them. 4, Cal. 4.
All right. So plaintiff's exhibit number 4 will be admitted. And for the record, so it's clear, this is a aerial view of the property located at 1439 County Road 111. Also marked on it is a circle with an X in the middle, which the plaintiff has testified indicates where his cattle would normally graze, I would say.
Eat out of a feeder.
Eat out of a feeder, all right. And then otherwise marked on another part of his property is an X where it's indicated that was where the fence line was and where the fence was damaged by this calf that went through. Is that correct?
No.
No?
Damage, they cut it. The
Okay.
calf didn't damage it.
The calf didn't damage it. The calf went through, and so the fence had to be cut, I guess, to return the calf, correct? That was my understanding of what happened, yes?
Yes, the fence was cut. No, it didn't have to be. When I had a rank heifer in.
Okay. I don't care why the fence was cut. The fence was cut though, right?
Right, correct.
Okay, in June of 2021.
Right.
Okay, got it.
And then there's the repairs.
Okay. Here, you've submitted as plaintiff's exhibit number 5, an invoice or a payment receipt from New View Fence Company. Have the defendants been able to see this?
No.
Okay. You could approach. Review that. Do you have any objection to that being admitted as an exhibit?
No.
Okay, all right. All right. All right. Any other testimony you'd like to present?
I don't think so. No.
All right. Any cross-examination?
Yeah. Yes, you are.
Right, that's all right. If you could do it at the microphone, please, that we can have a record. At the podium microphone, if you could. Thank you. Yes.
They're tools.
You had a bull, which, you said it routinely went through our fence, both on the far end, which you testified, and at where the reliever gate was, correct?
I'm not sure I understand the question. Say it one more time.
You had a bull,
Yes.
and the bull was continually entering our property through both the far end and the gate. That's the devil. That's the guy. Okay.
Oh,
That's okay.
okay, right?
Do you have any idea how many times that bull has been on our property?
No.
Do you have any idea how many times we called the brand inspector for that?
No.
Do you have any idea the damage he did to our property?
No.
Okay. Do you have any idea how he threatened our grandkids?
That's ridiculous.
Did I send you a letter in June stating that about grandkids?
It's still ridiculous.
How much did that bull weigh?
That bull weighs about 750, 800 pounds.
That bull weighs about 14,
He's a miniature
1,900
Hereford.
pounds.
He's a miniature
It
Hereford.
wasn't miniature, it's a short leg Hereford.
We ask
Anyway, okay,
questions.
all right.
Let's ask questions.
Okay. Do you know, what is your definition of a reliever gate?
It doesn't exist. It's some silly thing you made up.
Okay. How many ranchers do you know?
Do you have a question for me?
Yeah, I do have a question for you. What?
Wait a minute. That was a question. Just answer the question. How many ranchers do you know?
Probably 4 or 5.
Okay.
Okay.
Have you ever seen a reliever gate like this at any other rancher's house?
No.
Never.
This wired thing?
Yeah,
No,
a wire reliever gate. No?
no.
No. Have you ever used that reliever gate to your own benefit?
I know you said I have, and I can't confirm or
Can't
deny.
confirm that? Do I enter exhibits or how does this work?
Yes.
I can, okay. I'll introduce these 2 pictures. They're dated. I'm a wildlife fanatic. Not a fanatic, but I'm kind of crazy. So I have trail cams all over because I like to see wildlife.
Okay, don't have to explain it. Just show them
All right.
whatever you're going to show them.
I've got
Let's keep going on this.
these 2 pictures. One, they're dated January 3rd, 2023. I believe these are Bob's cattle coming back through the reliever gate.
All right, just show them the,
Bob on his truck,
okay.
same date. That,
Okay,
so you use the reliever gate, even though it's not a reliever gate.
whatever it may be.
Submit those as defendants exhibit A and B. Is that right?
Yes.
Okay.
You're,
Any objection to these exhibits?
No.
All right.
in your,
The exhibits will be admitted.
in your exhibits, you had, a picture and you said, oh, this just keeps adding up. And one was of a round feeder, which we,
I'm gonna give you a tiny bit of a spoiler, but not really. None of this matters. Nothing that they're saying at all matters at all for this case.
we had, which was disassembled and leaned against the fence, correct?
Correct.
Yeah, you claim that, that was because the gate was so weak, right? That the cattle would, what reason would we have done that?
I have no idea.
Okay,
My only point was you put up the gate and then continued to pile stuff on it. That's all I know.
okay. Your bull, I estimate, probably weighed 14 to 1,800 pounds.
It's ridiculous, Dave.
And he came through the entire third whenever he wanted to, wherever he wanted to. I submit this as an exhibit. I apologize for the call. It's taken at night. But is this your bull coming through where we eventually placed our feeder?
I have no idea where you play. Oh, you're talking about at the gate?
At the gate.
Yeah, that looks like
Has
it.
he stretched the wire way beyond?
Yeah, because there's no separators.
Is that our fence?
Yeah,
No separators.
yeah, you have no separators.
Separators.
Holds the wire.
Okay, is this,
Yeah, that's my bull.
I'd like to,
Okay. All right. So defendants exhibit C. Can you tell me around approximately when this was? Is this September of 2023? Is that what's indicated by that date?
it's, yeah,
September 3rd of 2023?
correct.
Okay. So exhibit C will be admitted.
You said there were years and when did I promise you? When did I make a promise for anything? I said that I would do it. I don't go, I promise you I'll do it. Did I ever even talk to you about it?
I've never spoke to you again after you left the voicemail.
After I left what?
You left the voicemail.
Okay, fine. Okay, then I said we would put the reliever gate in, which we did.
No, that's not what you said.
What did I say?
You said, I cut your
No, I'm
fence
not.
to get my calf back,
Correct.
but don't worry, because I'll put a gate in.
Correct.
You didn't.
Okay.
But it's all irrelevant. I guess the subject, well, I don't know if I'm supposed to talk. Do I just? wait
Answer
for
the
this?
question, please. Just answer a question.
You said it was years that I never put the gate in. I'd like to submit two things here. One is a letter from the Snares who put the gate in. They are fourth generation ranchers in Teller County. You have objections to this?
It's irrelevant.
Please.
Right. Do you have an objection to this?
I have a picture.
Sorry, hold on. Sorry. Here. Do you have an objection to this letter being admitted as an Exhibit D?
My only question would be, we're here about cutting the fence. Does anything matter? To me, it's irrelevant. All of this is irrelevant. It doesn't apply to the issue at hand.
All right. It seems to indicate in this letter that in June of 2021, these people had a repair done and that these people are providing a statement. Do you have an objection to this letter, which is a statement signed by the Ethan Snare and Kenny Snare being admitted as an exhibit for the court to consider?
The only way I would, well, see, that's where I would object to it because it's irrelevant. It talks about fixing their fence. Doesn't matter. The whole, I mean, to me, Your Honor, this whole thing comes down to, did he cut the fence or not? He's already stipulated that he has. All the other minutia is irrelevant.
Sir, none of what you just said is relevant either. None of it. Nothing.
All right, so you are objecting to this as being irrelevant.
Well,
I actually
don't want to be
think it-
troublesome.
I don't actually think it's irrelevant. There would be other objections I would make, but it says that there was a reliever gate and a repair made to a 10-foot wide section of fence. So I'll just take that as being that a repair was made. I don't know whose side of the fence it was on. I'll read it further if
Yeah.
I need to.
I guess the only statement I would make in regard to that is my fence was not repaired. They repaired with that gate thing, which I refuse to call reliever gate.
Okay,
But whatever.
all right, okay.
This is kind of a very similar picture to what I've already presented, but here's a picture of the completed reliever gate and information from my cell phone on when this picture was taken.
All right. This is proposed Exhibit E. All right.
Okay. Yes, that looks like early on.
Okay. Any objections to
No.
Exhibit E? All right. All right.
That's all I have.
All right. Thank you. All right. Any redirect? Any other information that you would like to state after he's
No, I think
cross-examined
I
you on
have.
that?
No, I think I'm done.
Okay.
I don't have anything else to say.
All right. All right. I am taking,
Although, should I put as an exhibit?
he's very cute, but I don't
The
think I need
character?
it. As much as you can say a bull is cute, he's very cute. I will say that. All right.
The judge thinks the bull is cute.
All right.
I go away now?
Yep, you go sit down. Oh, that'd be great. Thanks. All right. All right. Well, based upon the information that I've received so far, is there any other information that the plaintiff would like to present as evidence in this matter?
No, I don't think so.
Okay, all right. In regards to the motion to dismiss for violation of statute of limit, or being barred by the statute of limitations, I am going to grant that motion at this time. I've heard no evidence that would toll the statute of limitations or avoid it in any way. It seems very clear that the action accrued in June of 2021. The action to seek damages in this matter was not filed until 2026, specifically February 19th of 2026. That is well beyond the 3-year statute of limitations that would be applicable in this matter for property damage, even for the damage of offense under the state statute, under the agricultural statutes. So I have not heard any reason that that would be told in this manner. As stated by the plaintiff, he has not heard from the defendants, never spoke to him again after the voicemail. Said the fence was cut, don't worry, I'll put a gate in. It seems like they have demonstrated they did put a gate in, as they said they would, of a reliever fence. I get that it is not satisfactory to the plaintiff. However, it appears that that was done. And if there was a additional action or that repairs that needed to be made or property damage that needed to be covered by the defendants, then an action should have been brought within 3 years of the damage to your property. So unfortunately, that expired in June of 2024.
May I make a little bit of a...
No, I'm making my ruling and we are done. I've heard all of the evidence that I need to hear in this matter. The statute of limitation bars your action. It should have been brought much earlier than it was. Unfortunately, you are almost 2 years too late in the matter. So unfortunately, I hope that the parties can go forward being good neighbors in the future. I'm concerned about that. But again, as they say, good fences make good neighbors, and I think that's what needs to happen in this situation. That is the ruling of the court. If you wish to appeal the ruling of the court, you may do so. You have 35 days in order to do that. And you would have to go online in order to find the standard JDF forms in order to perfect an appeal of the order of the court. But the request for damages in this matter is denied. All right, so.
So is estoppel, it doesn't apply?
No, it would not apply in this situation, sir. You needed to bring this cause of action by June of 2024.
Okay,
All right.
are we done?
Yes, we are done. Thank you, sir. I will maintain the record for an appeal in case you would like to pursue it. Thank you.
All right, this next case is way better, guys. We just went through all of that for no reason. She should have stopped that at the very beginning. She does stop this next one at the very beginning.
All right. Let's call 26S7 again.
So the woman who just walked up and put things down on the table, that's a lawyer. And I don't understand, I don't understand how that's a lawyer, because this is small claims court. So I thought, I was under the impression that you're pro se in small claims court. You can't have a lawyer in small claims court unless you in fact are a lawyer. But, oh wait. No, they have to have a lawyer because they're an LLC. So what happened was the woman took her dog. I don't know what kind of dog. Maybe they say it. I don't know. I'm sorry. Took her dog in to get dental work done. And then over a year later, she had to get more dental work done. So she took it to another vet. And now she's suing the first vet because she had to get more dental work done a year later. All right. And the woman who talks first is a lawyer. And the other woman, I don't even have to tell you, is pro se. You were going to figure that one out all by yourself.
The parties, I know, have had an opportunity now. You had to listen to the case that was called before yours. I thought that would go a little bit quicker than yours potentially. But if anyone has a motion for recusal, I would definitely entertain that now at this point in time.
Yes.
Okay, not from the plaintiff, how about from the defense?
Yeah.
Okay, all right. So are the parties ready to proceed in this matter?
Yes.
Okay, all right, and for the defense?
Yes.
Okay, so Ms. Purdy, would you like to make an opening statement in regards to the case?
Yes, actually, I want to
Okay,
give you guys.
yes, have the parties exchanged any exhibits that you propose to enter on the record? And do you need, well, first, before they're admitted or anything like that, do you have exhibit stickers that you'll need to use?
Already.
You have them marked? Okay, great.
Ours are marked A, B, C.
Okay, all right. And have you all discussed these exhibits? Are there, no, not yet?
We're just now changing.
Oh, I see. All right. Okay. Do you want to take a few minutes and maybe look those over, see if you have any objections to them at all? I always encourage people, if there's any chance of a resolution before going to trial, that maybe that should happen. But I don't know if you might want to take that opportunity or not. How about I give you a total of 15 minutes? It looks like there's quite a few
I'm
things.
fine with mine. Yeah, I already have all this.
Okay. You have no objections to any of their exhibits?
No.
Okay. All right.
Just to expedite things slightly, what I've been trying to flip through all of the exhibits to see
She's the lawyer, the one speaking right now.
if there's anything in there in the nature of expert testimony,
Right.
and have not found anything. And perhaps we can just clarify, because I understand a certificate of review was filed indicating there was someone who reviewed our client's records and expressed opinions, but I
Right.
haven't found anything in the exhibits reflecting any opinions about our clients.
Mhm. Is there going to be expert testimony presented?
The clinical summary of multiple professionals and
But are you having that witness come and testify today?
no, but you can call whoever needs to be, either either of the veterinarians or my witness that was there for the consultation can be available by phone.
Okay, you have to have consent to have them testify by phone. That has to either be agreed upon by the parties, or you have to file a motion for consent from the court in order to have them do that.
Okay, well, but I submitted everything I have. The testimony in the clinical records or clinical summary and reports are pretty substantial. That's why I filed with the court for the in-camera filing.
The
for
in-camera review was
the
to just make sure that you could have an actual court trial, that you got across the line of the preliminary finding that someone was going to give an opinion.
But the opinion in writing doesn't count?
No, I'm assuming there would be an objection to that as hearsay, correct? And also,
I mean,
Why would that be hearsay, though? I mean, I have the physical evidence. I have two different clinical summaries from two different professionals. I mean, like, this is,
sorry,
and it's a repeated.
hold on,
offense.
let me make her record as
Sorry.
well. I made an assumption there. I didn't even let her make her record.
Oh, I apologize.
I think medical records are business records. I think there's a basis to present medical records. But what I'm seeing is this dog had a dental by Dr. Voles. A year and however many months later, sometime later, has had other dentals, which is what,
A corrective procedure.
that's what we don't have. We don't have an opinion saying that there was negligence on the part of Dr. Voles or negligence on the part of Dr. Westermeyer, who's saw the dog for other things in the year following, which then caused the need for dental, as opposed to
You guys didn't hear this because I cut it out, but at the beginning, the judge said to both of the parties, by the way, that's my veterinarian. Haven't been there in 3 years, but that's been my veterinarian for years. So the judge knows the doctors.
the dog developing.
They said they did not want her to recuse herself. She said, I'll recuse myself, no problem. And they both said, now you're good.
The problems that dogs develop, especially small breeds, and All right, you remove those teeth, now they've got gingivitis by these teeth. So there have been further treatment. And in fact, we would hear the testimony of Dr. Westermeyer that she had also said, well, if this is getting worse, you're going to need to come in and have further dental. So the medical records will establish that there has been treatment, but I don't see anything, and that's why I'm asking, are we missing something? If there's something she's presenting to the court where it says in there that because of something that was done wrong before, this has now led to an injury that would not have been there if it had been done right.
Yes.
So that is the causal problem and the lack of standard of care as to what was the standard of care, what did he do, what did he do wrong? That's what's missing. And I cited the case in the complaint, in the answer that I filed, providing the plaintiff notice as well, here's what's required at trial. Here's the veterinary case saying that you're going to need that on standard of care. So that's our position. If there is no evidence on standard of care, then it should be a judgment for the defendants.
I believe there are statements to that effect in this, the experts. If you give me a minute, I can find this.
Okay, guys, that was the last little tiny piece of sanity you're going to hear for the rest of the stream.
So my question is my specialist and my follow-up veterinarian have both given me clinical summaries where their notes have referenced that roots were left in the mouth causing the infection. And then the specialist cited repeatedly that she removed not just the roots in question, but also additional teeth that he marked as extracted that were not extracted, and that's what made the infection spread. Is that going to be good enough, or do I need to go get I can get a direct statement, or I could even subpoena them to testify if that's necessary. I was attempting to not interrupt their practice.
The information that was provided previously was that there is a specific statement from your medical professional stating that they were going to give an opinion that what was provided, the care that was provided was negligent.
So you want, I can request that they come to court or make a statement. The summary, we had a lot of discussion, me and the specialist, and it was, I just didn't bring her here today to say that. I thought the clinical notes and the summary statement of that would be good enough.
I didn't know that I needed to bring evidence to the trial, Judge. How am I supposed to know that I need to bring evidence to a trial?
But if I need to get
an opinion that says another doctor was negligent, one doctor saying the other doctor was negligent.
Okay, I can obtain that if I can get a continuance. I didn't realize that specific.
You indicated in the filing to the court that is what the doctor was.
I submitted what she said with that filing. And I didn't understand that was insufficient, or I would have gone and they will give me that.
We're representing yourself in this matter.
Yes, I thought we were all representing ourselves. That's why I kept it in small claims court. Until they gave us a notice of appearance. So my question is you want the specialist and or the veterinarian to specify that Dr. Volz was negligent. The summary of finding things that he said was completed but not and causing the infection is insufficient? Because I don't understand why that wouldn't be enough.
No, the summary you provided is inaccurate.
How so? I'm sorry, I'm just confused.
The summary you provided previously said that you had a medical expert who was going to testify that the level of care that was provided previously was negligent.
No, I didn't. Okay, so I don't think it says testify. I know that we had a discussion and that was discussed, and she said that she would put in her summary, which I felt she did. You haven't seen, did I file the summary? I must have. Because I don't understand why what I have is not enough, unless you need her to specify that David Volz is negligent specifically, because what else would you call it?
Yes,
it wasn't just negligent, he was.
Yes,
I'm sorry.
Specifically, it has to say negligence. That is what the law requires. And that was what I ordered you to provide.
It wasn't just negligence, it was misrepresentation. It was deceitful. He lied. And then falsified records that caused this to go on.
Now we're getting into something completely off track.
No, what I
that is not
I don't
what we're
understand.
dealing with here. I am talking about statute 1320-602 and the requirement that I had you file documentation about this.
Yes.
And you made a representation to the court about the information and the documentation that was filed under seal.
Mhm. And that was my
And-
information that I had.
And that representation that veterinarian was to testify and.
No, ma'am, I never said that she was going to
All right, then-
testify.
Then,
I didn't understand. I thought when I submitted
your
that, that would have
representation-
worked.
okay, so I'm not having an argument with.
No, I'm not trying to argue. I'm trying to understand.
And what I need you to do is to stop talking so I can finish.
Okay, I
the record
apologize.
here. So the information that was provided pre-trial
Mhm.
was insufficient to get past that statute. Because if you do not have someone who will testify that these veterinarians provided negligent care, then you are not entitled to have a court trial on this matter.
I received a note in the mail that it was, that all the information I submitted in camera satisfied that certificate. I have it right here.
Well, because your representations were inaccurate as to what you were going to be able to present.
I
Now,
presented,
all right, then we're done arguing. I'm going to find that you have not met the initial burden under 1360,
I have
1320-602 to demonstrate that you have another veterinarian
I
who
do.
will present an expert opinion
Can we
that
bring
these
her in?
veterinarians were negligent.
They weren't just negligent, they were,
As a preliminary matter, in order to bring an action under the statute, you do have to provide.
I did provide that, and I got a response in the mail from this court that said that they had, that information I filed in camera satisfied the certificate of review. I have it right here. It says that.
Yes, I know, I wrote that because based upon your representations of what you were going to be presenting.
The representations were actually the evidence I had to
Obviously, that
satisfy
was-
that.
No.
So then why was I,
That is inaccurate then, ma'am. It's
why is it inaccurate if you said that it satisfied it? Like I gave you what I had. If that was not sufficient, shouldn't that have been notified to me then?
You're right. Then I made an
I'm
error
sorry.
in finding
I mean, I just
your
didn't
information
understand.
to be accurate because I took your representations to the court as honest.
They are
and
honest.
Accurate and truthful.
They
And
absolutely were.
They were not, ma'am.
What
You
wasn't
indicated
true?
that you would have someone here to provide expert
Can you
testimony.
provide me where I
as
said that?
negligence.
Because had I known that's what I needed, that would be happening today. You never told me that
We are
that was.
done arguing about this.
I'm
ma'am.
not arguing.
Your
I don't
case is
understand.
dismissed. You have not met the preliminary standards under 1320-602.
Thank you.
See if I pull them out. All right.
Thank you.
Make sure I didn't take some by accident. Oh.
Apologize for wasting your time today. Thank you. 26S1, unless a representative from Fred's Towing comes back and has asked for an additional alias summons to be extended there, that matter will be dismissed. All right? Have a good day.
Thank you, Your Honor.
I left that have a good day and at the end because I loved it. Oh, gotta turn the fan because no one likes when I have air on me. Not my kids, not my cats, not my chat. All right, guys, thank you for coming out today. I had some good clips that I wanted to show you. I'm so glad we got through them with no technical issues today, I don't think. Do we have a technical? It doesn't matter. We had a good time. Thanks for coming out. I really, really appreciate it. Unfortunately, today's Saturday, ain't it? Ain't it? Yeah. That means I won't see you till Sunday night. Whew. That's so far away. But hope you guys stay safe. T, I hope your cat's okay. Thanks for coming out. I'll talk to you again soon. Bye, guys.
song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so